And those the major issues in the land today, and as far as the campaign train is concerned. So a major story today, if you heard, if you have not, is a Supreme Court judge ruling, or order rather, restraining the federal government from implementing the February 10 deadline for the old 200, 500, and 1,000 Naira notes for to stop being legal tenders. 3 northern states, which are Kaduna, Kogi, and Zamfara, they went to the Supreme Court. Some people will say the right place to go, because if there is a dispute between the federal government and the state, Supreme Court usually settles them. And so they went and prayed the apex court to halt the Central Bank of Nigeria's Naira redesign policy. Let's get some expert opinion on this. And there's some confusions. Don't forget, there was a High Court order saying that the CBN, or the federal government, that cannot suspend the policy. Now, the Supreme Court has weighed in. This is an injunction, in some lawyers would describe it, meaning hold on this particular matter until we hear the substantive matter. So let's get some perspective from a very senior lawyer in the land, senior advocate of Nigeria, Mike Ozekhome, a professor of law. Congratulations on your professorial cadre.
Thank you very much. I appreciate you.
It's good to see you.
Welcome, Nigerians.
Yeah. Brand new elections
we have here.
Yeah, thank you so much.
Country.
Everyone that's come here said so. Thank you so much. I appreciate it. Good to see you again, Mr. Ozekhome, or Professor Ozekhome.
In fact, someone congratulating me said, you know, Nigerians love titles.
Yeah.
He said, he started the letter like this: High Chief, Professor, Doctor, Sir, Barrister, Mike Ozekhome. And I said, so which one do you want me to wear?
Which one do you prefer, though?
Well, I've used Chief long enough.
Yeah.
I've used Doctor long enough. I've used Sir long enough. I think there's no harm.
Is using professor. Professor.
I'm a professor.
And you look professorial too. Thank you so much, Prof. So let's get started. The matter before us this evening is the Supreme Court and the order given today. Help us make sense of the order by the Supreme Court, which it gave on the Naira swap policy of the CBN in view of the existing order of the Federal High Court, of the High Court.
I will start like this. It's like the relationship between the Agama lizard and the crocodile. They all belong to the same class. They look alike. But we know who is superior. In the hierarchy of Nigerian laws, the Supreme Court is the apex court. That is why they call it Supreme Court. Supreme, beyond which there is no other court. And what that means is that all other courts in the hierarchy of courts must blow muted trumpets when matters are being heard. So, notwithstanding the fact that a high court or federal high court had granted an order telling the CBN, you can stop this Naira swap policy on the 10th of February, as you have decided to do. The Supreme Court today said, hello, don't do that. Allow the old and new Naira, allow everything to be in the same position. We call it status quo ante bellum. The state of affairs before the crisis broke out. Allow it to continue. Come back on the 15th of February and let us hear you people. Let me say this. Let me enter a caveat for Nigerians. The Supreme Court has not decided the matter. All it has done is to fall back to a decision like Kotoye versus CBN, that in matters of extreme urgency, you can grant an interim order, even if it be ex parte, to prevent the rest, the subject matter of the suit being truncated. If, for example, the Supreme Court does not make that order, or did not make that order, and the only order existing is that of the High Court, it means that the CBN, by 10th of this month, will stop the use of all old notes. But what the Supreme Court has said is, just wait. Let us listen to you people. Not that it has decided that Zamfara, Kogi, and Kaduna states have any valid case that is actionable, because the action is already being challenged with a preliminary objection. It is another way of saying, let us first drive away the fox before we blame the fowl for wandering too far into the forest. So it has not decided. It has just left the matter in a state, what we call status quo, ante bellum. Let it just remain now until we hear you people. So, but one advice I think I want to profile here is that if you notice, the judgment, the ruling by the Supreme Court was by a full constitutional panel of 7 justices. This is the type of case I think the Supreme Court should invite amicus curiae for singular, amicae curiae for many. That is, friends of the court. They should invite very respected senior lawyers to come and give their opinions in writing to the Supreme Court. And I also believe, if you ask me, 3 attorneys general of 3 states, Kogi, Kaduna, and Zamfara, have gone to court. Question: any decision arrived at by the Supreme Court, will it not affect the other 33 attorneys general of Nigeria? The answer is in the affirmative. It will. I also think that this is the type of matter in which the Supreme Court should also, suo motu, even if they do not apply to be joined, join all the attorneys general of the Federation, so that the matter could be decided once and for all.
For non-legal minds, they will be asking the question, why did the case just went straight to the Supreme Court?
Yes, that is going to be a very contentious matter. I'm not here to prefer solution or to side one party against the other, but I think it will be in the interest of Nigeria to throw up the issues so that particularly non-lawyers, non-legal minds will be able to understand the issues arising. There's what we call the powers of the Supreme Court. It has appellate jurisdiction. It also has original jurisdiction. Appellate jurisdiction is that a matter travels all the way, maybe from an area court or magistrate court, through the High Court, Federal High Court, through the Court of Appeal, and up to the Supreme Court. Then the Supreme Court can hear it. That's its appellate jurisdiction. But there is also what we call its original jurisdiction, which is in section 232, subsection 1 of the 1999 Constitution. And the original jurisdiction has to be for cases that concern whether facts or law, in which the existence of a legal right is involved between a state and the Federation, or between states and the Federation, or between a state and a state. The Supreme Court has original jurisdiction
to come in and settle the conflict. Let us see what happens to the case in the at the High Court, where some political parties had gone and they got an injunction of the court to tell CBN not to suspend the policy. What happens to that now that this case has gone to the Supreme Court?
I've already answered it. I said the judgment or the ruling of the High Court must blow muted trumpet. This is the big masquerade. The Supreme Court of the land has come out to speak. The little masquerade.
We'll have to keep short.
We have to keep short.
All right. Let's look at the implications.
Look at it this way.
Okay.
There will be chaos and anarchy and confusion if 2 courts that are dissimilar in terms of potency and power, begin to wrestle with each other, throwing mud on each other. The Supreme Court is called the apex court. And in the case of Adegoke Motors Nigeria Limited versus Adesanya, the Supreme Court said the Supreme Court is final in the sense of all finality. It is final not because it is infallible. It is infallible because it is final. So we can't be talking about a judgment or a ruling of a high court here when the big master has come out to roar. The lion has roared. The antelopes, for now, must keep quiet.
Let's look
so that
at
there will be no confusion.
Let's look at
That's why you call it the hierarchy of courts.
Let's look at the implications of all of these cases to the average Nigerian. And I mean, maybe you have some of the new notes. Maybe you don't have any problem with the policy, or I mean, just like some other Nigerians. But in your own view, Leonard Sik, what do you think are the implications of this policy, the timing, the manner in which it has gone on the average Nigerian?
Let me shock you on Nigerians. I only saw the 500 Naira note one, just one piece.
The new note.
The new note. I saw it. And someone said, that's the new note. And I said, this note that looks faded, even before it has been used, I compared it with the present 500 Naira notes bearing the portrait of Zik of Africa, Dr. Nnamdi Benjamin Azikiwe. And I saw that the quality is simply not comparable. One looks like a very fake version of the other. So, yours sincerely, I've only seen one note, 500. I've not seen any other. So the question of even having money.
So you've experienced the scarcity too?
Now, of course. Now, let me tell you what is going on. Nigeria over-dramatizes. That is why I've said we don't even practice democracy.
What do we then practice?
That democracy, that system of government defined on November 19, 1863 by Abraham Lincoln in his Gettysburg Declaration. I've said elsewhere that we practice one, electionocracy. Electionocracy is a system of government by which every 4 years we go into the ritual of electing our governors and president and senators. And after electing them, they use 1 year thanking the electors. They use the second year working. By the third year, they have started electionary campaigns. So there are no democracy dividends. Now, I said that is electionocracy. We also practice judocracy. Judocracy is a system of government in which voters vote. Votes are counted. The votes counted. Then the quarreling politicians go before a court of law and start fighting each other. The matters get to court. A governor is midwifed and delivered in the bowels of either the High Court, Court of Appeal, or Supreme Court, which may go against the will of the people as expressed in the ballot box. That is what you call judocracy. I also say we practice executocracy. Executocracy is a system where the executive arm of government superimposes itself and terrorizes the other arms of government using its hooded security agents to terrorize them. Then finally, I said we practice legislatocracy, a system where the legislature is a Mr. Yes, Sir, President, or Mr. Take a Bow, Senate, when a person is to be screened. And this legislature makes laws not for the good governance of Nigeria, but for everything where budgets are padded and where under sections 88 and 89 of the Constitution, which are supposed to be their oversight functions, they have to ask for padding of their own budget before they can approve. So these are the systems of government I say we operate.
You don't think that we have grown at all in our democratic
Oh, no,
practice?
we have not grown. Look, Sheung Okimbaloye.
From 1999.
We have not grown. It's stunted at best. It's stunted growth. I will call it the fate of the barber's chair. Look at it. This is the fate of the barber's chair of perpetual motion on its axis without progress. That's what we have been experiencing.
Oscillating at one spot.
Oscillating, at times even retrogressing.
But let them say,
just a moment. Let me tell you why I'm saying this. How many Nigerians know that after Queen Elizabeth II died in September last year, that his son, Prince Charles III, who is now King Charles III, has since become King of England? Let me surprise you, and many Nigerians who may not know. The Bank of England, since December last year, rolled out a policy that by mid-2024, that's giving about 1.5, almost 2 years ahead, the present £5, £10, £50, 20 will see to be legal tenders. So between now and then, the Queen of England's face and head are still of the currency. Now, how many Nigerians know that the title Queen's Counsel, QC, which is the equivalent of our SAN, Senior Advocate of Nigeria, has since been changed to KC, King's Counsel? There was no brouhaha. There was no rokos. There was no wahala. How come a mere change of currency by the Central Bank of Nigeria should lead to a country bleeding, asphyxiating, politicians screaming, common people dying on the streets, fighting? Did you not see some viral video? I cried. I was with my wife. I shed hot tears. The young man stripped himself naked to the shame of a country. What was he saying? He said, I have over 500,000 Naira in this bank. All I want to make my family survive, if I can just get 100,000, I will be okay. They told him he could not withdraw. He had no old notes. He had no new ones, but he had the money in the bank. The young man went berserk. The kind of things that lead people to commit suicide. He stripped himself completely naked. I burst out crying. I told my wife, I wish I know where this young man is based, or where he is from, or how to reach him. I will rush some money to him. I cried. I'm not saying metaphorically. I'm saying literally. I cried. If my wife is watching this program, she will know that I cried. And she had to give me a tissue paper to wipe my face. I was touched. So, why do we use simple policies to self-immolate, self-destruct? How come a mere policy? I mean, we have been having, the CBN has been there. The time frame has been there in the last 1 year, 2 years. You could have started a policy like this gradually. I'm not saying the fiscal policy is not good. I must not be misquoted. It has its own inherent advantages. Mopping up money from the lecherous and satanic and luciferic hands of politicians, which they use to buy votes. I'm not therefore talking about the merits. It has great merits. But in talking about merits, you also have to look at the disadvantages. They first started by saying you can only withdraw 100,000 Naira in 1 week for an individual, and 500,000 Naira in 1 week for a company. When we cried out, they expanded it and said, okay, an individual can now withdraw 500,000 Naira a week, and a company, 5 million Naira. So you are saying a company like Julius Berger, Dantata and so, Cetraco Nigeria Limited, that do business big business, road constructions. The only money they can withdraw in a week is 5 million naira. And an individual, when my running costs of my chambers alone, my running costs alone in a week is more than that amount they are talking for a company. You are saying all I can withdraw is 500,000 naira. That was the joke of the century.
If you were to advise, because elections are just 16 days away, and my question would be, would it have any consequence on the conduct of the election? Although the INEC chairman said, we are all clear, it won't have any consequence. But for the voters, in terms of the logistics of INEC, they say they're all clear. But for the voters, would this policy impact on the psyche or in any way they affect the conduct or the voters in any way?
It will affect politicians and vote buyers more than the ordinary citizen. Because usually a voter registers close to his house. There's no question about that. In some isolated cases, they may have registered in a place far away. But the people that will be most hit by this policy, and that is why those who have been crying more have been the politicians, at times using the ordinary man and woman as surrogates to protest and barricade roads so as to show how bad the policy is. Because they no longer have access to cheap money. But by the way, a friend asked me, he said some of the politicians may not even be affected. I asked him why. And it surprised me. And it was a matter of fact. He said many of these politicians we are talking about actually own the banks. So if a bank is to dispense money, it will first give money to his oga, his boss, before thinking of others. Nigeria is a captured state. Nigeria has been captured by non-state actors, by the elites, rich individuals. There are some individuals that are now richer than Nigeria. Of our 21 trillion naira current budget, is it not only about 8 trillion that we can say in terms of revenue? The rest is to be borrowed. So Nigeria is borrowing her future and future generations to the 10th generation. We are in trouble. Make no mistake about that.
Let me take you slightly away from the conversation of the CBN policy to yet another legal matter. I'd like to get your view on the Supreme Court judgment on the Yobe Senatorial District election, which submits that the current Senate president is the candidate of the APC for the Senatorial District.
Well, that judgment, with all respect, actually came to me as a surprise. What I've tried to do as a constitutional lawyer is to discuss issues dispassionately. Because if you discuss issues based on your likeness for one individual or one political party or the other, by the time those individuals or those political parties are no longer there, you may find yourself in future beclouded by that your past genie that you let out of the bottle. So that is why I can comment on that case, because it is a judgment that has been decided. Delivered. And I'm a teacher, I'm a lecturer. I'm a professor of law. So I critique and I criticize. The Electoral Act is clear. Look at sections 83, 84. Look at the Constitution itself. If a candidate dies, for example, the political party can bring forward another candidate for them to hold a fresh primary election. In the same way, a candidate may decide to resign and say, yes, I've won this position as a senator. I'm not going again. Then all that the political party will do is to hold another fresh primary. We don't call it a rerun. It's not a rerun. It's a fresh primary under the Electoral Act.
That is what the Electoral Act provides.
Thank you.
Shall I read? I mean, for our viewers.
Yeah.
That's section 84.
84. That's what I said, yeah.
Section 84(1) says, a political party seeking to nominate candidates for elections under this act shall hold primaries for aspirants to all elective positions which shall be monitored by the commission.
Yeah.
Subsection 2 says, the procedure for the nomination of candidates by political parties for the various elective positions shall be direct, indirect primaries, or consensus.
Yeah.
Then, yeah, that's what it says.
Check 83, let's see.
Yeah. Yeah, 83 is also talking about monitoring of political parties.
Yeah.
Yeah. I guess where you're talking about is where it talks about
check 81. Trying to zero in on this section.
Yeah.
Dealing with a candidate voluntarily withdrawing.
Okay.
No, 33, sorry. Go to 33. Go to 33. Go to 33.
Political parties changing candidates. A political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by the candidate.
Yeah. Yeah, go.
Provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the commission for the election concerned.
That's the section. Section 33. In case of death or withdrawal by candidate, the political party will now hold another fresh primary to be monitored by INEC. Coming to this case of Machina, yeah. Machina and Lawan, the Senate president. Nigerians beheld when Senator Lawan contested the presidency. That is, he contested for the position of president in their primaries, in the primaries of the APC. He did not win. If Machina had withdrawn voluntarily under Section 33 of the Electoral Act, then a fresh primary would be held within 14 days. But the facts that I have that are in the public domain is that barely a day after the presidential primaries of the APC in Abuja, Machina, who had already won, was said not to be the candidate again, but that it was now Senate President Lawan. The question there came, when did APC give notice to INEC that we are going to have another fresh primary? Did Machina himself, who was already elected, did he say, I have withdrawn, such as to even give an opportunity for a fresh primary to be conducted? You cannot have two obas in one palace.
But I mean, let us say, so, the premise upon which the Supreme Court gave this judgment was on the procedural law.
Yeah.
That the filing of the case at the trial court was wrong. And upon that technicalities, the Supreme Court struck out the case.
The Supreme Court has warned us again and again that the era of technicalities over substance, the era of form over substance, the era of technicality over justice is gone and buried forever. If you look at the case of Attorney General of Oyo State versus Bello versus Attorney General of Oyo State, decided in 1986 by the Supreme Court, you will see the beautiful dictum of great jurists like Oputa, like Kayode Esho. He said, and when the spirit, when the apparition of technicality comes out of their graves, clanking their manacled legs, he said, you should put them back in the graves where they belong and do substantial justice. We are talking about serious matter as the representative of the people. And the people have chosen their own representative. then you are elevating the issue of form, procedure, of how a case was filed, to say a person who did not participate in the primaries, who was never voted for by the people, we now go and represent the people against a person who was popularly voted for. Let me tell you what is going to happen. I can see what you call protest votes in that constituency, in that senatorial zone. With all respect, the Supreme Court is not just a court of law. It's also a court of policy.
Yeah, policy.
And that is why I'm always defending the judiciary and the Supreme Court, because when we violate it, when we allow it to be violated, there will be trouble.
All right. Let us say, let's close on this note. We just have 30 seconds, and I'd like to get your view. Since the emergence of the new electoral law of 2022 and this election that we have at hand, what do you expect from the 2023 election? What are your expectations? Just in 30 seconds.
Expectations, 2023 elections, Nigeria will not break into smithereens, as some people have predicted. Some emergency pastors, imams, Nigeria will break. Nigeria is not going to break. God is a Nigerian. We will still wake up after 25th of February. Nigeria will still be united. Yes, there will be violence in some places, here and there, pockets of violence. The beavers has come to stay, but even within the beavers, there could still be some form of manipulation, but not on the kind of large scale we have been seeing before now. It will minimize it.
All right.
There will still be electoral malpractices, but not at the level we have been seeing it. And Nigeria will still be there. But let me say this. The next coming president, whosoever you may be, and listen to me loud and clear, your first function, the first thing, even if that is your only thing, if that is the only thing you do throughout your session, convene a national conference, whether you call it sovereign or whatever.
All right.
Allow the people to make a people's driven, autochthonous, indigenous constitution by the people, for themselves. Subject it to a referendum and plebiscite of the people, so that you can have a people's constitution, not the present decree number 24 of 1999 that we call the 1999 Constitution.
Thank you so much indeed.
God bless Nigeria.
Professor, Doctor, Barrister, Chief.
Don't be like that person who wrote me the letter.
I don't want to be found guilty of not giving you your rightful titles. But thank you so much. Always a pleasure learning law from you. Thank you so much.
Nigeria is a beautiful country. When you travel out, when I travel out of Nigeria, within 10 days, I'm already itching to come back. There's no country like Nigeria.
Absolutely. We love this country, and God bless Nigeria.
Dolly Parton's coat of many colors.
Thank you so much.
God bless Nigeria.
Ozekhome, as an advocate of Nigeria.